Now, we've seen the presentation by the Human Rights High Commissioner in Geneva. He suggests that in the recommendation, in the main recommendation, it says that an establishment of hybrid court with including the international judges. At the outset, don't you think that this is a stepping stone for international inquiry?
Yes, in fact, the High Commissioner has recommended, based on our findings, our extensive findings of the kinds of very serious violations that took place in Sri Lanka between 2002 and 2011, but also prior to that. We have found that the violations are systemic. There are patterns of violations. Now, we're not talking about pockets of crimes that were committed, but violations that must have taken a lot of planning, resources, and coordination, and where the command structure needs to be investigated, as well as the immediate perpetrator. In order for this to occur, we think that it is very important that the kind of judicial process that takes place is a hybrid process. Now, when we're talking about hybrid, we do not mean an international court. We mean international and domestic combined. So with the integration of international prosecutors, international judges, and international investigators. And the reason why we believe this is particularly important is, as I said first, this is a commission of very serious international systemic crimes, including war crimes and crimes against humanity. Secondly, Sri Lanka has had many different processes over the years, commissions of inquiry, etc., which have failed. The victims have not found justice. Now, the victims fall in several categories. Some of them are afraid. They're afraid to speak out because in the past they have faced reprisals for speaking out, or they have been actively intimidated and prevented from speaking out. Another category of victims are those people who have just lost hope. I mean, after giving testimony to successive commissions, filling out many different forms, and seeing no results, you lose trust. It will take a very long time to rebuild this trust. And this is why we feel that it's important to have an international element to restore some of this trust and faith to the victims.
Ravina, however, the government of Sri Lanka, including the previous government and even the present government, has said that they would go on a domestic process, not an international process. And also at the same time, they have said that even at this on Monday's presentation, Sri Lankan Foreign Minister very clearly stated that if you even go to the extent of amending the criminal code or the penal code and bring new legislations into the country's legal framework. Now, in this backdrop, how optimistic the UN Human Rights Council, Commissioner's Office, that Sri Lanka would basically adhere to these recommendations?
So we very much welcome the speech by the Foreign Minister and the kind of courage and leadership that the President has shown as well. And there have been some advances in legal reform and in redressing some of the problems, the problems of the past. However, this is not enough. The Foreign Minister said that we need to trust them. In fact, it's about the victims. We have to keep coming back to the victims. It is not about what the international community wants or what the government of Sri Lanka wants. It's about what the victims need to have genuine justice and reconciliation and reparations. And it is about ensuring that there is non-recurrence, that what happened in the past cannot happen in the future. And that can only happen, first of all, with true justice and accountability, and secondly, with deep-seated institutional reforms. Over 30 years, the democratic institutions in Sri Lanka were slowly eroded. And there was systemic violations and systemic kind of abuse of power that took place. It will take a long time to fix that. And that can be fixed through legal reform. And again, we welcome some of the legal reforms that the Foreign Minister spoke about. And it goes through institutional reform. And it's also a fundamental change in the way that officials perceive the democratic institutions.
Don't you think that if the government of Sri Lanka perhaps changes its stance to include or accommodate the international judges into a hybrid court, that there will be a lot of agitation from the public, because the government, they may not have trust in the government, including the previous government state, and promise that there won't be an international inquiry, but even the new government of the state. In that backdrop, do you think that it is feasible for a legitimate government to basically engage in such an exercise which they have promised to the public that they would not do?
I mean, first we encourage all the people of Sri Lanka, the public from whichever ethnicity, from whichever political background, to really read this report and to study the findings carefully. And once they have seen that, we ask them to discuss, for there to be a dialogue and a discussion on the recommendations as well. This needs to be a consultative process. This is not something that would be imposed from the outside. The whole point is that this needs to be a victim-centered, victim-driven process. There need to be consultations on how. We've come up with a proposal that there needs to be a hybrid court, which means there needs to be a combination of domestic and international elements. Beyond that, we have not fleshed that out. That is something that needs to be done in consultation with the government, in consultation with the public.
Ravina, in this report, it basically indicates the violations of both the human rights violations from both the government and the LTTE. But now the LTTE, in this backdrop, now if LTTE is a terrorist organization, now how are you going to bring the law before a terrorist organization that has existed in this country? And how are you going to do, even if you bring a hybrid court or whatever, international experts or lawyers or for that matter, how are you going to get an ruthless terrorist organization before this kind of an exercise? How come the public has a trust like that?
No, indeed, we have documented horrific violations committed by the LTTE as well as by the government forces and the paramilitary groups as well. You have exactly pointed out the complexities of this process. This is not a simple process. We are talking about the alleged commission of war crimes and crimes against humanity. In the international sphere, we have a lot of experience in dealing with such crimes of such nature because these are international crimes that we're talking about. There have been many courts that have been set up in Sierra Leone, in Cambodia, etc., where both government and armed groups have been brought to justice. There's a considerable degree of experience and expertise there, and precisely because it is so complex, there needs to be an international element in the investigation, in the prosecution, and in the judicial process.
But don't you think that they'll simply escape? Now today, if you try to find who were the people who basically ordered the atrocities of everything from the LTTE point of view, are no more. And how are you going to, there may be a few people who are right at the moment. Now how are you going to pinpoint and get them before the law in this kind of an environment? Because they can simply escape, claiming that they were a terrorist organization and they are not bound by any law and order, because anyway simply they are a terrorist organization and they simply escape. And then who are there right now physically to basically to capture?
So you pointed out several problems. One is that at the end of the war, according to the findings of our report, there were many people who allegedly belonged to the LTTE who disappeared or who were killed. This made justice very difficult. When they're dead or disappeared, you can't bring them before a court. These issues need to be addressed. However, I think you might be aware that recently in a court in The Hague, in the Netherlands, there were several financiers of the LTTE who were brought to justice and who were convicted of financing, of fundraising for a terrorist organization. And they were charged in, among their charges was war crimes. It is possible to have justice. It is possible to bring to justice not only the direct perpetrator, not only the person who planted the bomb, but the financiers and the people who held command responsibility for that. And this recent decision in The Hague shows that it is possible. And the other thing is where justice in a way is made impossible by the fact that some of these people have disappeared or have died. It is still very important to have a truth-seeking and a truth-telling process for the victims. The victims' suffering needs to be acknowledged by telling the truth about what happened to them, by making this a historical account. And this is one of the pillars of transitional justice. You have to have truth-telling, you have to have justice, and you have to make sure that these violations do not occur in the future, non-recurrent.
Yeah, and also right now the LTTE leader is no more, and subsequently his subordinates also no more. And but they have done enormous atrocities in point of view from the LGT point of view. And now you said that you can go into other areas of financing the terrorist organization and get them before the law, but they with the legal system, like they may but see the amount of atrocities. Financing could be totally different to responsibility of mass destruction and etc. etc. So in that backdrop, don't you think that for them there is only things like possibility for them to get into the cage from the point of view from terrorist organization in this kind of an exercise if executed?
No, we have documented, as I said, violations on both sides, very serious violations, which may amount to war crimes and crimes against humanity. Justice needs to be done. As I said, there are 4 pillars of transitional justice. Where justice is not possible because the perpetrator is dead, there still needs to be a truth-telling process. That in itself is something that the victims are entitled to, that they have a right to. And there is a reparation process. You need to acknowledge the harms that they suffered, and there needs to be reparation. And then this needs to be studied. I mean, you've exactly pointed out that you're not just talking about the perpetrator, the exact direct perpetrator of the crime, but you're talking about command structures, and you're talking about a very complex operation. International law allows for the prosecution of people who have command responsibility. When you're talking about the commission of international crimes like war crimes and crimes against humanity, it is very important to tackle those structures. And this is why we are suggesting a hybrid court, where we will be able to support the domestic process and to take it forward.
Coming back about this LGBT factor again, we have now some of the LGBT leaders who have entered into the mainstream politics in the recent past. Will they be also looked into being brought before the book if this process goes through?
Now, in this report, we have not named individual perpetrators because this was not a criminal investigation. This was a human rights investigation. And we are stressing the need for a criminal investigation, the need to establish individual criminal responsibility for the perpetrators of these crimes, no matter who they are.
Okay. In the report, there's one recommendation that establishing an office of the Human Rights High Commission in Sri Lanka, which was totally rejected by the previous government, and present government also, I hope, that they have not yet commented on establishing any office of the Human Rights High Commission in Sri Lanka. In this backdrop, do you think that could be done in this country, because the rule of the country has not basically welcomed this kind of an exercise?
Well, we very much hope that this position will change. I mean, as I said, we are encouraging everybody in Sri Lanka, regardless of their political affiliation, ethnic affiliation, etc., to study this report very closely. The findings are of a very serious nature. The problems are of a very deep-rooted institutional, systemic nature. We are ready to assist, and we have, in many other countries, been able to assist the transitional process, and very successfully so. I'll give you the example of Tunisia. After the overthrow of the previous regime, they invited our office to set up an office in Tunisia, and we have been working very closely with the government to accompany the process. We've been helping them to do consultations for a constitutional revamp. We've been helping them to reform their institutions. We've been doing training for police officers on interrogation methods that do not involve the use of torture. A lot of things, and we've been accompanying the process. Now, this is not it's not a supervisory role, and it's not, kind of a penalty against Sri Lanka. Not at all. On the contrary, this is about accompanying the transitional justice process and ensuring that these kinds of violations that we've reported in this report never occur again.
Finally, what should Sri Lankan government now do after reading this entire report? On the 30th of this month, I think this report will be officially tabled, brought before the Commission. What the next step the government should do now in order to face this challenge at the office?
Well, once they've carefully studied the recommendation, we invite them to engage with us and with the international community to implement the recommendations. And this means action. This means beginning a process where judicial investigations will take place and prosecutions will take place. Legal reform will take place. Institutional reform will take place. It's time for action.